name is Laurie Steiner. I'm a partner at the law firm of Steiner Peck. And we're talking today about the good, the bad, and the ugly new rules for retirement accounts for Medicaid eligibility purposes. This is kind of what I do on a daily basis. And they keep changing the rules. They keep trying to make it harder and harder. So we try to bring you information through these Tuesday talks and emails and other ways, and Facebook. We have a YouTube page. So if you want to see this webinar again, or you want to see any of our previous webinars again, you can always go to our YouTube page. It's Solomon, Steiner, and Peck, and they're there. So, and you can also link through to some of those through our website, which is ssnplaw.com. So with that, why don't we get started? Because it's about 4 minutes after 12. So again, welcome to our webinar. And we are talking about Medicaid in particular, but this is all part of how to pay for long-term care. It's really hard. And the issue with long-term care is it's happening more and more as people age. So some of the statistics there on the screen, I think are kind of scary. Between age 65 and 69, you have a 1 in 2 chance of a nursing home stay. Now that might just be a little rehab following surgery. It might just be a fall and you need to get back on your feet, get a little rehab to get going again. But there are a great many people who stay much longer than just a few days or just, a couple of weeks. The average stay in a nursing home has been holding steady about 2.5 years based on some surveys. The problem is the cost, man, it's getting to where it's $96,000 to $144,000 a year. In the Cleveland area where I practice, in case any of you are out of the area, a couple of the nursing homes are now topping $14,000 a month. So the issue of how to pay for this long-term care is pretty big. And Medicaid is one of those programs that can help you pay. Another statistic, 50% of all couples, of couples who have one spouse in the nursing home and one spouse at home lose all their assets within a year, partly because the facilities expect you to pay until the money's all gone and then apply for Medicaid. But there are planning tools. So we are looking at financial devastation, and the programs are complicated. Special needs is complicated. I was working with a family yesterday for their daughter, and they want to know, why is it so complicated? Why can't people just understand and they have information out there for what to do? And I fully agree with that. Medicaid is the same way. So at one end of the spectrum with special needs children, the parents are trying to figure out what to do. At the other end of the spectrum, we've got seniors whose families are trying to figure out what to do. And it's not easy. So how do you pay for this nursing home care? Well, self-pay, that's exactly what nursing homes would rather have paid, because they make more money from self-paid private pay than they do from the reimbursement they get from Medicaid. And that's what Medicaid wants to do, because they don't want to pay benefits. Some people have long-term care insurance, which helps pay a per diem amount, like so much per day, towards long-term care costs, whether it's at home or assisted living or in the nursing home. Those of you who are veterans or have a spouse who was a veteran, even if they passed away, there are some veterans benefits for vets and for vets' families and for the surviving spouse of a veteran, but that is a little bit limited. Some people who are trying to stay at home take out what's called a reverse mortgage on their property. They can borrow money against the house and they don't have to make monthly payments, so they can tap into the equity to help remain at home. But that doesn't solve the problem if you have to leave your home to go into a facility. The reverse mortgage has to be paid off within a year. So it's only helpful if you're trying to stay at home. There's Medicare. A lot of people think Medicare is going to pay for the long haul at the nursing home, but they really don't. It'll pay up to 100 days, basically, if you're in the hospital previously and you meet the requirements when you're transferred to a nursing home for rehab. The most you're going to get under those circumstances is 100 days. And if you have to stay longer, it's not going to help pay for that, which brings us to Medicaid. So I'm going to go over some of the basic rules for Medicaid, and then we'll talk specifically for a little bit about how IRAs are being looked at differently now. So for Medicaid, it is a long-term nursing care program, and the government helps you pay for those long-term care costs. Most of the time, we're dealing with Medicaid in a nursing home, but there is a Medicaid program in the community. They consider an assisted living facility being in the community. And there is some assisted livings take Medicaid, and there is a program for Medicaid at home called the Passport Program, which doesn't pay like the room and board like it does in the nursing home or assisted living, but it pays for people to come in to help you out in your home. We're mostly dealing with Medicaid applications when it comes to a nursing home because the cost gets so tremendously high. People don't even have in many cases, don't even have a shot at being able to pay for it. The problem with Medicaid, there's only about 40% of residents in nursing homes who are actually getting Medicaid. The other 60% are typically paying privately, or there might be some small percentage where Medicare is paying for it yet after a hospital stay. But a lot of the reason for that is people don't know it exists or don't know how to apply. And the facilities say, well, when your money's all gone, we'll help you apply. The Medicaid program is a federal program that each state has to follow, but each state has the right to make tweaks to their program. And that's one reason why Ohio is currently making this tweak to their program with regard to IRA accounts. Some states completely exempt IRAs. Some states completely count IRAs as part of assets for eligibility purposes. And Ohio is kind of in transition right now that we're going to be talking about. Even within the states, the counties differ on how they are looking at these rules. For example, in Ohio, Cuyahoga County is recognizing the beginnings of this new IRA rule, and most of the surrounding Northeast Ohio counties are recognizing it and following what the rules will be. But there are still some counties out there, mostly a little bit more southern, that say, no, we haven't gotten any official information yet from the Ohio Department of Medicaid. So we're going to go with the old rules, which we're going to go through. So there's even within the state of Ohio, which is, we know, making changes, county by county, you could run into difficulties. So just some quick background on how assets and income rules work for Medicaid. If you're single first, that's simpler. For income eligibility, if your income is greater than, your gross income is greater than $2,382 in 2021, you have to set up a special kind of irrevocable trust called a qualifying income trust. That's been around since about 2017 when they started enforcing it. So that's a hurdle that people didn't have to overcome before. Before, it used to be as long as your income was less than the nursing home cost, you could qualify for Medicaid. But now they've added this little extra twist and people don't know about it. So I'm trying to get the word out there that even for income purposes, there are some new rules in the last couple of years. You get to keep a personal needs allowance of $50 a month to spend on haircuts or laundry or whatever you want. You get to keep enough to pay health insurance premiums. And if you have old medical bills, then they can allow for some payment of those. From an asset point of view, everything is countable. You're pretty much not allowed to keep more than $2,000 in assets, except you do get to keep a car if it is used for transportation. You get to have a little plot of ground to be buried in. You get to have a funeral contract as long as it's irrevocable. And the funeral homes know how to do that, so I'm not going to go deep into it. And you're allowed to keep your stuff, your personal items. So you don't get to keep very much if you're single. Married couple rules. If you're married, it's a little bit different because there's two people involved. And typically only one is in the nursing home and one is still living in the residence house. So for income eligibility, whose income it is based upon the name on the check rule. Whose name is that check made out to? And that's who they will count the income towards. Just like for singles and the income rules, if your income is less than the nursing home costs, then you qualify for Medicaid. But now, if your gross income exceeds, the one in the nursing home that is, gross income exceeds $2,382, you need this special qualifying income trust again to run your money through. So you got to be aware that there's something else out there besides, I can't afford to pay for this. Medicaid makes determinations on who they think can afford and cannot, and you have to jump through hoops if your income's a little too high. Also, the person in the nursing home getting Medicaid gets to keep their $50 a month personal needs allowance, enough to pay health insurance premiums and past due medical expenses. Plus, if the spouse at home doesn't have quite enough income, if they're not quite at poverty line, a couple $1,000s, according to Medicaid, then part of the nursing home spouse's income can be allocated to the spouse at home. That's the MMMNA, the minimum maintenance needs allowance for a spouse at home. As far as assets go, they do it a little different because there's two people here, and you can't just look at the one person being applying for Medicaid. They got to look at all of the assets. So they add everything up as far as assets go, and between husband owns, wife owns, jointly owned, and there is a amount that can be allowed to be kept, and then everything else has to be split. When they're adding up all these assets, it doesn't matter if you have a prenuptial agreement, because they will count all of both assets anyway. Even if your prenuptial agreement says, second marriage or third marriage, his is his and hers is hers, and we're not sharing for Medicaid purposes, they don't care. They're going to add everything together anyway. And for a married couple, one car is exempt, cemetery plots for both, irrevocable funeral arrangements for both, personal items of both, and also a house can be exempt as long as one spouse is still living there. Then everything else is countable assets. And the one in the nursing home keeps $2,000, and the one in the facility and one at home gets to keep half of those countable assets, but not less than $26,000 and not more than about $130,000. So that means if you've got $30,000 worth of assets that are countable, $2,000 is kept by the one who's in the nursing home. The other one can keep as much as $26,076. That's more than half, but that's the minimum, and they have to get rid of a little bit of the money. If there is $500,000 worth of assets, half would be $250,000, but that's too much. Medicaid caps it at $130,380. So the one in the nursing home keeps $2,000. The one out of the nursing home keeps $130,000, and then the rest is what they have to get rid of for Medicaid eligibility purposes. So those are the rules as they have been actually for quite some time for both, for the single individuals and for married couples. And the rules would include IRAs. So under the old law, an IRA counts as an asset, and it has to be spent down just like any other asset. So when we were talking about that, say your $500,000 was, some of it was $100,000 was an IRA, and the rest were just other assets like investments or bank accounts and CDs and things like that. The spouse at home could only keep $130,000. And yes, if it was a $100,000 IRA and it was the spouse at home's IRA, they could keep it as a part of their $130,000. But if it was the asset of the one in the nursing home who could only keep $2,000, then there's $100,000 that individual, the nursing home spouse, has and has to get rid of in order to qualify for Medicaid benefits. The problem with that is that IRAs typically, in order to get rid of them, you have to liquidate them. And by liquidating them, you incur a really big income tax. You're taxed on the whole thing. If all you're taking out is, your annual required minimum distribution each year that IRS makes you take, you're paying income only on that income that you're getting for that year. You're not paying income tax on the whole thing. You're only paying income tax as you take it out. So that was always a little bit unfair in the past, that this big chunk of money has to be liquidated in order to qualify for Medicaid, because it would cause, in some cases, if you had a big enough IRA and some other income, you could be paying 50% of that IRA amount, the account that's 100% income taxable. You could be paying 50% of it to the IRS and to the state of Ohio before you could qualify for Medicaid. And that just seems like an awful waste of money. So the Medicaid, the Ohio Department of Medicaid must have been considering that as an issue. So they are changing the law. Now it's not completely clear yet. And I was hoping I would get final clarity before we try to present this, but I don't know when that's ever going to be coming with the pandemic. They're much busier trying to figure out how they deal with folks who are sick and how they evaluate assets and things if you can't get to the bank in order to get the proof of your assets when you're applying for Medicaid. But so far, what we know, in at least in Cuyahoga and most of the northern counties, and as I said, not in every single county in the state, they have changed their viewpoint on IRAs as an asset. Yes, it is a pot of money in the bank or in a CD or an investment account, but what they're going to do is they don't count it as an asset when they're figuring out that amount. Like if you're single, you get to keep $2,000. If you're married, they look at everything and then you get to keep some part of that. They would exclude that, exempt that as an asset, as long as it is an income turned into an income stream for you. So that means if you're over 70 and a half in the old days, or now it's 72 and a half, where you have to start taking IRS's required minimum distribution, the RMDs, out, then they will consider the IRA not an asset, but an income stream. So you get to keep the underlying pot of money, that IRA, that 100,000. Or I have a client who I've been working with that got over $1.5 million in IRA money, and that would all be exempt as long as that person is taking the required minimum distributions and you're in what they call payout status. So if you're in payout status, if you're the one applying for Medicaid, your entire IRA will be exempt from that, but the income you're getting on an annual basis, many people take it and the check annually, but it's better for Medicaid if you can take it monthly, because Medicaid figures out your income on a monthly basis. And remember, you have to pay most of your income to the facility, except for a few items like your personal needs allowance of $50 and health insurance premiums and old medical bills and things. The rest of your income pretty much goes to the nursing home. So the pot of money doesn't count against you. Now, if you're taking required minimum distributions and that throws your monthly income over that $2,382 limit for having to set up a qualified income trust, then even though your income, your regular income is below that amount, that required minimum distribution adds onto it and can put many people into the need for having to set up that qualifying income trust. And again, you got to have that in place the month you're applying for Medicaid. You got to know ahead of time that you're going to need that and have it in place, so that it doesn't take, when you apply for Medicaid, it might take Medicaid a month or two to get back to you with information that they need, and so that they can process things. And that month or two that you're waiting for that letter from them and you're providing information to them, if you don't have that QAT in place the very first month when you apply, they will not grant you Medicaid those months when the QIT is not in place. So that's kind of interwoven with this new IRA rule. It's going to cause more and more people to need that qualifying income trust and may not know about it. So that's why I'm emphasizing you're getting more income. It's going to count against that gross amount of income that you might need for a qualifying income trust. But at least you saved the 100,000 or the 1.5 million like my one family has. One problem that we don't know the answer to yet is that there's this program called Medicaid Estate Recovery. And the state of Ohio feels entitled to recover from whatever assets you have left when you die after you got Medicaid. to repay the state of Ohio for these Medicaid benefits they paid out during your lifetime. That's what the Medicaid Estate Recovery Program is all about. So if you're single and you have $2,000 left in the bank and that's all you got, plus you might have a car because somebody had to drive you around in it, or a wheelchair van or something like that, those assets Medicaid let you keep while you were getting benefits because they're exempted. But when you die, you no longer need those, and Medicaid Estate Recovery will take your $2,000. It'll force the car or van to be sold, and they get the money from that. So it's kind of stands to reason that Medicaid Estate Recovery may now come after this IRA pot of money, where they're letting you keep it while you're alive so that income stream can help pay for the nursing home. When you die, you don't need that pot of money anymore. So they may come back and say, well, thank you very much for, we let you have that. Now we get to repay the state of Ohio for all the benefits that the state paid out on your behalf through the Medicaid program. We don't know for certain if that's going to happen. Most elder law attorneys that we're all talking about it, we think that is probably going to happen. So that's a big risk. Also, what if you're under age 72 and a half now and you don't need to be taking required minimum distributions? So if you're too young, or there are alternate ways to deal with this, you can also annuitize your IRA. So that's a little bit different. When you're just keeping the pot of money and the money's coming out, you still have that money available to you. It's still a pot of money. If you have to annuitize it to get the same result, annuitizing an IRA says, I'm going to take my $100,000 and turn it into income stream. The $100,000 is gone. You can't touch that anymore. You have a guaranteed then income stream for life or for a number of years. So annuitizing is a little bit different. It is an option, and sometimes we have to look at that as an alternative to keeping the pot of money and just having the required minimum distributions coming out because of the Medicaid estate recovery against the pot of money. The problem is when you annuitize an IRA, the payment stream comes out to the person who annuitized it for lifetime. And then their way of doing Medicaid estate recovery on annuities of any sort, including these IRA annuities, is to name the state of Ohio as the beneficiary after your spouse. So if you're married and the husband's in the nursing home and he annuitizes his IRA, the money that he's annuitized, that monthly stream, will go to the nursing home month by month. When he dies, his spouse will continue to get that income stream for her lifetime. And when she dies, before the kids can get anything, the state of Ohio has a right to estate recovery through that annuity. So there are alternative ways to deal with this, but it's not always great. It's kind of the ugly part of things. We don't know completely. We know what the annuity rules say. We know what Medicaid estate recovery says right now, but they haven't put them together yet so that we know for certain that the pot of money that's remaining is actually going to be subject to the estate recovery rules. So, and here are some other issues that we don't know the answers to yet. We do know that Medicaid, the Ohio Department of Medicaid, is working on answering these kinds of questions, but they don't have the answers yet. I am on a committee of elder law attorneys who meet with the Ohio Department of Medicaid legal department on a quarterly basis. We have another meeting coming up in October. This will be the third one this year. And we've been asking all year, when are you going to get those rules together so we know how we're actually going to have to deal with IRAs? And they've been promising and promising and promising. They are working on a Q&A. It's just pages listed with, well, what about this situation? And then the answer. And what about this situation and the answer? They're about to 9 pages or so right now, they tell us, but they're not done yet because it's so complicated. And especially if there's a married couple and both have IRAs, it's terribly complicated. And they're really struggling with coming up with answers to these, which is why we're struggling with how are we best going to use this new rule to the benefit of our clients. So here's one question. So what they're talking about when they say you're taking your required minimum distribution, your RMD, and that changes your IRA from a asset into an income stream, because that's really what you're doing. You're just taking income out of it on a monthly basis. And that income, for the most part, is going to the nursing home. But what if, let's say the husband's in the nursing home and it's his IRA, so the money is mostly going to the nursing home, but the wife is at home and she's in the house that is protected, but she doesn't have a whole lot of money remaining after spend down for Medicaid, and the roof goes bad. What if they try to dip into his IRA to take out a lump sum in order to fix the roof? So now you're treating the IRA both as an income stream and as an asset. You dipped into it. You took a lump sum of, $10,000 for a new roof. Does that cause Medicaid to say, oops, that is no longer an income stream. Now it's an asset. So even though we exempted that $100,000 IRA when you first qualified, now that you're trying to use it as an asset, what's left, the $90,000 that's left, now is an asset. You're over assets, and Medicaid will stop simply because you needed to dip into the actual lump sum of the $100,000 and potentially changed it from an income stream to an available asset. So we don't know the answer to that yet. We don't know what they're going to do. We do know that, remember last year in 2020, people weren't required to take required minimum distributions. So they were working on this rule in 2020 and in 2021. So if you're getting Medicaid in 2020 and you didn't take your required minimum distribution because the pandemic said you didn't have to, then your IRA would have been countable in 2020. But then when you're starting to take them again in 2021, it no longer is countable. So they're going two ways on this thing. Some people had to take an RMD last year, otherwise faced losing this exemption for their IRA. This is way at the end of the year that this was starting to be talked about, and we've been waiting and waiting and waiting for answers to these kind of questions. So next question, and I don't have an answer for these for the most part. What if both spouses have IRAs and one is over 72 and a half and have to start taking their RMDs, but the other one is not as old? They're a few years younger. So the spouse that has the IRA that is over 72 and a half takes their RMDs, and that IRA is an income stream now. It's not an asset, and that IRA would be exempt. The other one, that IRA will be countable, and they'd have to get rid of it to get the assets down to the appropriate level. But one way that you can avoid that is have that younger spouse start taking required minimum distributions anyway. Even though they're not required yet, there is the table in the IRS rules that say, well, at 72 and a half, you have to take this much out, this much percentage out, and at 73 and 74. But they have the table start younger than that as well. So you can look at, well, for somebody who's 67, this is what the amount that you'd have to take out to be a required minimum distribution. So the younger spouse would have to start taking their RMD in order to have the pot of money be exempted as and turning it into an income stream. So now there's options. Do we want to do that? Do we want to instead liquidate that one IRA? Maybe it's not very big, so we liquidate it. Maybe the couple has very high medical expenses because one of them has been in a nursing home. And even if they liquidate the IRA, it won't cause a terrible tax consequence because they're going to have so many medical bills to offset that income that it's okay. So there's a lot more planning that has to go into deciding how you deal with IRAs, that it's difficult. And as I mentioned earlier, we think Medicaid estate recovery will take the remaining IRA funds unless you have a surviving spouse who can take them. So let's say husband's in the nursing home He's got his IRA and he's taking RMDs. So the pot of money is exempt. When he dies, if he names his wife the rollover beneficiary for his IRA, then she starts taking his required minimum distributions, and it's still exempt because they are not allowed to take Medicaid estate recovery against a surviving spouse. I mentioned the annuity earlier. Same idea, except that in the annuity type, it's annuitized, the stream of money goes to the husband, and then she's the beneficiary of the stream of money. And then when she dies, Medicaid takes the stream of money. Here it's a little different because this is a pot of money that the husband had that's exempt because he's getting required minimum distributions going to the nursing home. When he dies, the pot of money then becomes the wife's, who then has her own required minimum distribution coming out. And they're not allowed to take Medicaid estate recovery against the pot of money, not the income stream from it like an annuity, but the pot of money itself until the spouse dies. The children are the ones who lose out in that situation because Medicaid might take it all to repay themselves for all the Medicaid benefits the husband originally got during his lifetime. So we're looking for ways of how are they going to track that? Can they actually keep track of this husband died, he had an IRA, it went to the spouse, now she's taking it out and using it, and they have to keep track of when she dies so the kids don't get it. The reality is, I think they'll try to do a Medicaid estate recovery, but it's going to be difficult for tracking it. How do they keep track of this one IRA account for one family out of thousands of families who are getting Medicaid? I think that the rule will probably be there, but I think it's going to be very difficult for them to enforce. So we're looking for ways to protect it still, so that if the husband has it and his income from the RMDs is going to the nursing home and he dies, then the wife has it and she's taking it out for herself. And then when the wife dies, how do we make sure the children will get it? You know, that is still an open issue, and how they're going to track that and how they're going to actually achieve things with trying to keep track of that money. All right. Now, another thing is, remember when I talked about the rules for Medicaid eligibility for income for a married couple? How do they determine whose income it is something called the name on the check rule. Whoever's name is on the check is the one whose income is allocated to. So if the husband's the husband's name is on the check, it's his income. And if he's the one in the nursing home, it's part of the calculation of what he pays to the facility. If the wife's name is on the check, it's a part of what they calculate to see if she has enough money to continue to live in the community and is above poverty line or not, so that some of the husband's income might come to her to help her get above poverty line. So they're looking at, and they don't look at the underlying asset. What is paying this check? Usually it's pension money or Social Security, so it makes sense. But there's a way that you can choose to take distributions out of an IRA or to annuitize it and make a choice on what name is on the check. It doesn't change the tax consequences. So if the husband's IRA is the one that's generating a check, whether it's just an RMD from the pot or whether it's been entirely annuitized, so its pot is gone, they just have this right to an income stream. If it's the husband's IRA, he's taxable on that earnings that comes out. But there are some companies that will issue payments out to the family using the wife's name instead of the husband's name. It's an irrevocable assignment of the husband's right to that check to the wife. So one way we are looking at trying to get the spouse more out of that pot of money from the IRA, or more from that annuitized pot of money for the IRA, is to have one of these companies change the name on the check. So the husband's IRA funds are going to the wife. By doing that, the wife has the access to the money and it's not being used as a part of the income of the husband. towards his need for a QIT. Remember, if his income was over 2382. And it also avoids the money just being paid right to the nursing home on a monthly basis. So there is this in amongst RMDs and annuities and cashing out, there's the name on the check rule. So by changing how Medicaid is looking at IRAs, they have also raised many, many issues as to planning tools and whether or not they'll work anymore, or whether something new is going to be available in the future to try to protect some of that money. And it's much more complicated. If you have significant IRAs, you really need to get some help planning with this, especially since you'll never get the straight information from Medicaid, and we're still struggling trying to figure it out as well. We are in the committee that I am on, talking to the legal department at the Ohio Department of Medicaid. We're pushing them. They've got their hands full so much with the pandemic, they're just putting it on the back burner. But we need to know. This is complicated stuff. There's just so many unanswered questions that we have, and it's difficult to, give you good advice, but we're doing our best. We are trying really hard to understand what they're doing and even put on spreadsheets. What if we do it this way? What's going to happen? What saves the most money if we do it this way, part, number A, or we do it letter A rather, or do letter B? These are possible plans. What's the way that we anticipate will save the most money for the family? And my point of view is always get Medicaid and protect as much money as possible. So this has caused sort of a monkey wrench in how we would typically always do things in the past for many years. Some states exempt IRAs entirely. So if they exempt them in this way, even if the income goes to one of them that might go to the nursing home, when that one dies, Medicaid does not go after it with Medicaid estate recovery. There are a number of states that have taken that position. We're hoping that's what Ohio does. We are advocating for Ohio to do that because it just doesn't seem right. They're taking the income all these years, and then they're going to go and take the actual remaining account. Just doesn't seem right or fair to, especially to the children, who would be the ones who would ultimately lose out when the surviving spouse, if there is one, dies. So I hope you see that this is not a simple issue right now. We're working on trying to work around it. So how do, at this point, you protect yourself? You need to find out more information, like coming to this webinar today. I know I don't give you a whole bunch of answers, but the questions are out there and we're working on it. At some point, we will have the answers for Medicaid because we're going to kind of push them into it. But you can't trust what you hear from the County Department of Job and Family Services, who administers the application process and the ongoing eligibility for Medicaid services. You definitely can't trust the internet. Hopefully you've learned that one already. Medicaid is unfortunately not do it yourself. It should be. It's a program like a welfare type program that if you don't have enough money to take care of yourself, particularly in a nursing home, it's out there. The federal government and the states combine their monies in order to provide this service. It should be easy, but it is certainly not easy. You got to understand the rules, which we're trying to sort out for you. And you should really start planning earlier than the last second. The earlier you start thinking about these issues, the more chance you have to protect assets. For example, there is this 5-year look back rule, which I didn't really get into because that wasn't the focus today. But if you give away any of your money, Medicaid doesn't like it and will disqualify you from Medicaid for a period of time if you made those gifts within 5 years of the Medicaid application. So sometimes our planning is we're starting early enough that there's time to give away assets and wait 5 years before applying for Medicaid. And then those assets are completely clear, free and clear, protected. There's nothing that Medicaid can do about those. So there are a significant number of people who start 5 years or more ahead of time. If you wait until someone enters the nursing home and you try to protect money, we usually can do something, but we can't protect as much as if you start planning early. So, and we focus on on Medicaid and Medicare and VA and, special needs and things as elder law attorneys. I'm a certified elder law attorney federally and with the state of Ohio. That means I had to take a test, a day-long test, to prove I knew all of this information and all these different topics. It's different than just estate planning. Estate planning is getting your will in order, your financial power of attorney, healthcare power of attorney, living will, sometimes a trust agreement, which are all really important documents that you need to have, but it's only a part of what an elder law attorney can bring to the table in helping you plan for the future and truly protect your assets against long-term care in the future, and what tools will work for you to be able to do that. So that's what you can do to help your family. Search out as much information as you can. Take it with a grain of salt if it's coming from the agency providing the services, because they don't really want to provide the money, or the internet. See an elder law attorney rather than just somebody who can update your will. Lots of attorneys can update your will, but they can't walk you through the steps of a Medicaid application or a Veterans Administration application. So with that, we thank you for having come to our webinar today. Hopefully you learned something, or at least are aware now of what's going on and know the issues and pitfalls, because you got a plan for them. Medicaid isn't going to help you out in making those decisions. You have to get that for yourself. So is there any questions or anything? I got to thank you. So thank you for the thank you. Are there any other questions anybody has? I can answer them now. We will be sending out to everyone who attended a copy of this PowerPoint presentation, so you'll have it for yourself so that you can relook at it. And if you have any questions at any time, call the office, email me, email Debbie, who was the one who sent out the invitation for you guys. We will try to get your questions answered, because this is complicated stuff. And we just want to let you know what's going on with Medicaid so you can plan for the future. Anything else? Okay, I got a question. How long does Medicaid have to try and get their money back after someone passes? Good question. There is no real statute of limitations, which means if they're never notified that someone died. Now, typically they're going to be. If you're on Medicaid and you're in a nursing home, they have to notify Medicaid you died to stop your Medicaid benefits. So they're going to be notified. But there is also notification process through probate court. There's a notification process if you have a transfer on death real estate that you're transferring. They require you to answer the question whether or not you're getting Medicaid in the future. So that's how they also get notified. So if you don't notify them of anything, then they have no statute of limitations. We had one family where they came back 10 years later to try to grab back money from Medicaid estate recovery. Kind of difficult. Most of the money is gone by that point, but they have no statute of limitations. If you do notify them, then you have a year. So sometimes it's better off to just upfront go, hey, Medicaid, yeah, we know that there's a state recovery. We have 1,000 left in Dad's bank account. What do we owe you? And just to get it off the table and done with, because they can come back anytime and suddenly out of the blue, you'll get a letter. So when you say to get rid of money, what does that mean? The money can't be converted to assets like furniture, boat, jewelry, etc. So getting rid of money to reduce your assets to the proper level for Medicaid is either spending it down, which is, yes, you can buy your furniture. Yeah, boat, yeah, not so much. They allow one car to be exempt. A boat is a luxury. So they probably will count the boat against you. But if you need furniture, if you need to fix up your house, if you're married, if you need like a new roof, or you're going to pay, you can pay debts. If you have a mortgage, you can pay off the mortgage. If you have a car loan, you can pay off the car loan on the one car you get to keep. If you need clothes, if you need medications, if you need medical equipment, you can spend the money on all of various things in order to get rid of it for Medicaid eligibility purposes. Beyond that, we do enter into some planning that even if it's at the last minute, we can protect some of the assets by giving them away causing a penalty period, but we have to have enough assets left over in order to pay during that penalty period. That's kind of beyond what we were going to talk about today, but another webinar, hey, we might be able to go more deeply into that. But yes, you can spend it on yourself, spend it on bills. You can't give it away without causing a penalty period that we have to address in the planning. Any change in status for retirement assets that are not IRAs. Pretty much everything, I used IRA because it's easy, but it's all of these, any kind of retirement accounts where you put away money pre-tax and now you are taking it out at a certain age, the required minimum distributions, and paying taxes on it. So there are a few types of pension plans, company maybe based pension plans that we have to turn it like not liquidate it, but turn it into an IRA in order to do these things. But it's really IRAs I used synonymous with retirement plans, and I should have said that at the beginning and I forgot to. So anything else anybody's got? Last call, because we want to get on and let everybody get on with their day. Okay, 401k, yep. Same thing with 401k. It's a retirement asset. You have to start taking money out at the required minimum distribution age. So it would be a part of the status of retirement assets. Okay, anything else? If not, I'm going to stop sharing my PowerPoint. And thank you for coming to our webinar. Like I said, we're going to send out a copy of the PowerPoint. You can see this again on YouTube in about a week. You can look at any of our old webinars in about a week or so. And please email us, call us, whatever. We want to give out information. We want our clients and our friends who are out there, not yet clients, to really have good information and know what they're doing with, especially with regard to long-term care planning. So with that, thank you all for coming. I'm going to end the call. And thanks again. Have a good day.